Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On October 17th, 2024, the court entered an order sealing defendants' motion to adopt a voir dire procedure. It states, the court having before it defendants' quote, motion to adopt voir dire procedure and objection to, inner quote, magic question, end of quote, October 16th, 2024, and for good cause appearing, hereby orders that the motion be immediately sealed, pursuant to ICAR 32 I3A, to preserve the parties' right to a fair trial, the interest in privacy, dominate over public disclosure, and sealing it is the least restrictive way to protect the privacy interest at issue. It is so ordered October 17th, 2024. Judge Stephen Hippler, District Judge. I'm going to provide an opinion here, completely my opinion, under the First Amendment to the United States Constitution, freedom of speech, freedom of the press. My opinion is this is yet another example of the interest that the public has to be in any way, shape, or form reassured that the sole and correct defendant who has been charged ever in the atrocities that occurred almost 2 years ago at 1122 King Road is incarcerated, because time and time again we see this issue of privacy of individuals whose names are not disclosed are of paramount significance. Call for even the public not being authorized to know that a motion was ever filed by the defense on October 16th, 2024. Judge Hippler has ruled that the privacy interest of unnamed individuals supersedes everything here. I don't understand why the least restrictive way to guarantee those privacy rights for these unknown people override once again the public's right to know. Why couldn't defense's motion be redacted to the extent that any information regarding these unknown people would have been blacked out, would not appear on the court docket? In other words, why doesn't the public at least have a right to see the title of the motion, the signature block, the certificate of service, with everything else redacted? Because if you look at October 16th, 2024, there's nothing on the docket at all. The public docket anyway. And in my opinion, again, as I continue to give, this goes to the mind-numbing super-secrecy of this case. It is almost 2 years since these tragedies occurred. And what assurances do the public have when we have seen time and time again in this court docket documents withheld from the public to protect the life and safety of unknown individuals, if Mr. Kohberger is, according to the state, the only person that the public has been told is responsible for these crimes? It's not as if he's given day passes that he can go out if the public is made aware of these super secret filings to avenge, to go after these unknown persons. The only time that I can recall that the public's right to know has ever superseded the defense's, as well as the state's, demands that so many documents be withheld from the public and be filed under seal is when Judge denied Mr. Kohberger's request that all cameras be withheld from the court proceedings. That was Mr. Kohberger's request, that there be no cameras at all in the courtroom. This will now conclude this episode of the Indie Zone continuing series on this super secret Idaho 4 case. Thank you very much for joining us here today.